There's a lot to know when it comes to the legal side of owning your home, and that's why we bring in Kurt Franke each week to talk about the legal side of real estate. This week, Kurt brings in a topic that hits home for a lot of people, or maybe not as close to home as they might think. We're talking about construction defects, right?
Correct.
Okay, let's talk about the statute of limitations to begin with. How long can somebody be living in their home before that period ends?
Well, there's actually three different statute of limitations that apply. First, one for what's called patent or obvious defects. That's usually governed by a 3-year statute of limitations. And then there's a 6-year statute of limitation that applies to those defects that aren't so obvious, that the homeowner didn't necessarily know of. And I think there's certain presumption in the statute that certain items in your house should last that long. And then there's a 10-year statute of limitations for much more hidden defects and things that arise over a period of time. And it would, it's a case-by-case basis as to which one applies.
Okay, so now let's talk about the process when it comes to somebody going through possibly the litigation of this. What has to happen before they can even go back to the builder on this?
That's an excellent question, because in about the mid-2000s, I believe, the Nevada state legislature created a Chapter 40, which sets forth certain procedures that have to be followed before a lawsuit can even be filed. The idea being, let's try to get the homeowner and the contractor together, working in good faith, to get this thing repaired. In a lot of instances, contractors were ready to repair something but never had the opportunity before litigation was filed. In other instances, they weren't in such good faith, and that always spurred litigation.
And that's where the bond that so many contractors or all contractors have to carry comes into play, right?
And that's right. Essentially what the statute says now is that you have to notify the contractor, which seems like a fair thing, have to give the an opportunity to inspect your home and inspect the defect that you claim that exists, and then that contractor will go notify subcontractors if they're involved and come back to you with an answer. And that's what required by the statute, and say, I will either repair or I won't repair. And if they don't answer, that's the equivalent of I won't repair.
Okay. Now I'm going to put you on the spot. Somebody's been through all of this and they haven't gotten a response from their contractor. Can they call you?
Absolutely.
Okay.
Yeah, and I advise, you may even want to go through this process, taken through the process with an attorney, because I think those letters, one, have more impact, and two, are more to the point, and often people say things that come back to haunt them later, pre-litigation. So I think it's a good idea to go through the whole process with an attorney.
All right. If you want to set up a consultation with Kurt and find out exactly what this process entails, you can give him a call. What's the phone number?
827-6100, or you can check out my website, LOCAF, that's LOKAF.com. As in law office is Kurt A. Franke. If you call Linda, I'd be happy to talk with you and set up an appointment.
Great. Good stuff.
Thanks,
Kurt. All right. Now we want